a moment, an outstanding roster of international experts will join us to debate expectations for AI regulation, both within the Council of Europe and beyond. But first, we want to show you another clip from the documentary I, Human.
In China, everybody has Alipay and WeChat Pay. So the mobile payments is everywhere. And with that, they can do like a lot of AI analysis to know your spending habits, like your credit rating. Face recognition technology is widely adopted in China, in the airport, in train station. So in the future, maybe in just a few months, you don't need paper ticket to board a train, only your face.
So a potent reminder there of the speed with which technological development is moving, and of course with major implications for our society. So can those implications be addressed through regulation? Before I ask our panelists for their views on that, I would like to urge you once again to send in questions to us. I have a couple that were also posed for Gregor Stoyin that we couldn't get to because of time limitations, but I will certainly take them into this panel as well. If you send us your questions via our conference website, we do please request that you put in your name and organization if you're willing, because that is interesting, I think, for everybody to know where the questions are coming from. But if you prefer not to, of course, that is fine as well. So now it's my pleasure to introduce our guests, beginning with Daniel Luffa. He is Europe Policy Analyst at Access Now, which is an NGO defending and extending digital rights through advisory services, advocacy, legal and policy guidance. Focusing on facial recognition, which we just saw there in that clip, and biometrics, he serves as an observer to the CAHI and also a member of its working group on policy development, which helped draft the CAHI feasibility study. And he joins us from Brussels. It's also a pleasure to welcome Yoichi Ida. He is Director of International Research and Policy Coordination and Deputy Director General for G70 and G20 relations at Japan's Ministry of Internal Affairs and Communications. And he chairs the OECD's Committee on Digital Economic Policy and serves as a member of the Japanese CAHI delegation. Joining us from Tokyo. Welcome. Great that you can be with us. Also with us is Egor Shipitsin. He is Deputy Director at the Ministry of Economic Development of the Russian Federation. He's responsible for the development of artificial intelligence and innovative infrastructure, and also for foreign economic cooperation on new technologies and innovation. And he serves as Deputy Chairman of the Ministry's Expert Council for Innovative Development. Welcome to you, sir, and you joined us at fairly short notice. We're very pleased that you could be with us. I'm also very glad to welcome Matthias Spielkamp. He is co-founder and executive director of the non-profit research and advocacy organization Algorithm Watch. He's the former co-founder and managing editor and publisher of the magazine iRights.info, and he also serves on the governing board of Reporters Without Borders German section, and he joins us from Berlin. And finally, it's great to have with us Peggy Walker. She's professor of law and technology at KU Leuven University and also co-director of its Center for IT and IP Law, with a focus on AI in law enforcement, media, transport, and the judiciary. And she also serves as elected vice chair of CAHI. And she comes to us from Leuven in Belgium. So let us begin with the basic question of what should be regulated, because in fact, at present, there is no single definition of artificial intelligence that is accepted by the scientific community as a whole. So where should we start when it comes to the scope of a legal framework? Where do you see the most glaring legal gaps? And what particular practices or applications would you want to see become the subject of regulation? And I will go down the panel in alphabetical order, so that would mean that we'll hear first from Daniel Luffa.
Hi, thanks. Just to start, I'd like to say thanks for the invitation to the event, for all the organization that went into it. It's a real pleasure to be here on this panel with such distinguished fellow speakers. And thanks also to everyone who contributed to the work of the CAHI. I'll also in advance give a warning that there's works in the apartment above me. I asked them to please not make any noise during this time, but I can't guarantee it. The first thing I'd want to say is, I think we've heard people say this already, is that AI, automated decision-making, doesn't exist in a regulatory vacuum. There are many regulations across different regions that apply to this technology. Whether they're being adequately enforced is another matter. That being said, I think AI, ADM, and machine learning, does pose some unique challenges. At Access Now, what we're focused on is to address the human rights challenges. As regards uses, what I would mention first is I think the use of facial recognition for identification purposes and other forms of remote biometric identification poses an enormous threat to human rights in the way that it enables both mass surveillance and discriminatory targeted surveillance. What I mean by that is that state surveillance has historically been discriminatory against poor people, people of color, and other minorities, depending on specificities of the region. I think it's important to note as a frame that developments in machine learning over the past few years have made remote biometric identification much, much cheaper. They haven't made it better in any meaningful sense, and certainly not from a human rights perspective. Mass surveillance is not only a threat to fundamental rights, it's incompatible with the enjoyment and protection of our rights. Facial recognition, for example, can cause huge damage when it works badly. We've heard how it tends to work badly on darker skinned faces, but improving its accuracy and efficiency does not mitigate the damage it causes to fundamental rights. It only makes it more efficient at undermining them. Related to remote biometric identification, another use that I would like to point to is that we've seen a huge amount of research in behavioral and attribute prediction technologies. Some of this research, which is often publicly funded by universities or EU money, is incredibly problematic. And I would point to my discomfort with the way that Mikhail Kosinski, whose research is incredibly problematic, was featured somewhat uncritically in a clip from the documentary earlier, and I'll come back to that a bit later. But let me just take a seemingly simple example that maybe not a lot of people are aware about to show the damage that this technology can do, and that's automated gender recognition, or I would prefer to call it gender attribution. To some people, it seems unproblematic that machine learning system could be trained to classify people according to their gender. And such applications are in use in smart advertising billboards that claim to show you more relevant ads based on your gender. And there's even a girls-only social media platform called Giggle that requires users to submit a selfie, which is assessed by gender recognition software. The problem with this type of technology is that it infers your gender from your physiognomy, so from your face. And this is far from flawless, given that bone structure is a poor indicator of gender identity, but it essentially excludes trans women from joining. And this was the case with the Giggle platform. Such technology can have more serious consequences if used to control, for example, access to public toilets, and could even be used to out trans people in public spaces, potentially exposing them to the risk of violence. Beyond gender recognition, we've seen researchers such as Kosinski make ridiculous claims to infer sexuality, political affiliation, and even contentious attributes such as criminality from machine learning-based analysis of facial features. We need to ensure that applications of AI and automated decision-making like this, which are fundamentally incompatible with human rights and scientifically hugely problematic, are not developed or deployed. There are many ways in which this can happen, from outright bans to the enforcement of scientific standards, but I think we'll come back to that later. Thanks.
Thank you very much. And proceeding alphabetically, I will go next to Yoichi Iida with the same question, essentially the scope of what should be regulated. Where do you think we need to begin? What do you see as most crucial?
Okay, thank you very much for introduction, and very good morning, good afternoon, good evening to everyone. The AI is coming into our society and economy in every corner, and we see different services and functions working with AI. Even the air conditioning machine in my apartment is working with AI these days. So we have different types and different levels of AI functions in the society. But our basic idea is AI is still in its infancy, and we believe we should avoid hindering innovation by introducing binding regulatory framework too early. And we hope a soft law approach by non-binding framework will work effectively. Impacts brought by AI applications vary substantially depending on the context, such as the sectors and the use cases. And we find some doubt from the viewpoints of efficiency and effectiveness in setting cross-sectoral binding regulation on AI in general at this moment. So, of course, we admit there are gaps, especially in the transparency or accountability on AI, and we need to mitigate and minimize those gaps. But we are now studying how to control and minimize the risks and how to govern the AI systems, especially from the viewpoint of transparency and accountability. From the viewpoint of areas and applications, driving or facial recognitions or healthcare applications might have more serious impact, but we are still studying what kind of services and applications may have serious impact and what are the ways to control those applications. Our basic approach is to implement kind of field trials, sandboxes, and other activities in the approach of multi-stakeholder participation. Not only from the government, businesses, but also from civil society and consumer groups and other communities. So that people share the common understanding on how to manage the risks and also the benefits. So in the previous panel, we heard, we need to have a kind of a picture on future society. What kind of society do we want to have? And our government is promoting the concept called Society 5.0, which is aiming to achieve more inclusive and sustainable future society through full digitalization of economy and society. So this concept is, to realize the more equal and inclusive and open, sustainable community for not only for the young people or ordinary people, but also for the aged people and the people with handicaps and also other vulnerable people. To be included and to be more engaged in the society. So that is the way we want to develop the new emerging technologies, including AI. And we are mostly looking at the positive side of emerging technologies. Through the public consultations, we see a lot of support from the people in the country. So that is our direction, a little bit different from the mainstream of the discussion today, but I wanted to share this with you. Thank you very much.
Thank Thank you very much, and that's exactly why we're very eager to have international perspectives to understand how approaches differ. And I will ask all of our panelists to please pick up on what you hear from each other. So we just heard there from Mr. Yoichi Iida a definite preference for soft law because of concern about possibly disincentivizing innovation. And on the other hand, the need to begin with a very clear vision of what kind of society we want for the future. And I'm glad, by the way, that you mentioned potential age discrimination. We actually have an audience question on that, but I'm going to come back to it a little bit later, Mr. Iida. So also, just a reminder to all of the panel, we are looking for a lot of interaction amongst you. So if you keep your answers fairly brief, I would be very, very grateful to you. So I will move on now to Mr. Igor Shipitsin from Russia and ask also for your view on regulation. Where do we begin? Do we need it? And what are the most crucial areas to move forward on?
Thank you, dear moderator, dear participants. There is a high demand on AI technologies in the world. Each state pays special attention to this topic in the current age of digitalization. And AI regulation is both on the international and on the national agenda. International AI regulation will ensure equal protection of the rights of individuals everywhere in Europe and give the developers and applicants of AI clear legal framework for their activities and all the member states of Council of Europe. We believe that a legally binding, comprehensive international treaty will be the best contribution of the Council of Europe to international AI regulation. And in addition, this document should be accessible to all of those countries across the world. It should be founded on universally recognized principles. This document can become the basis for a better AI legal framework. And this document should be consistent and clear. So I'd like to tell a couple of examples of Russian AI regulation. So first, there's a government decree of the Russian Federation called on conducting an experimental on trial operation of highly automated vehicles in public roads, which launched the trials of self-driving cars in the public roads in Moscow. This experiment was extended to the Republic of Tatarstan, Vladimir, Leningrad, Nizhny Novgorod, Novgorod, and other regions from the period from 2020 till 2022. As many other largest cities of the world, Moscow has introduced special experimental legal regulation to facilitate development and application of AI from 2020. This experiment includes the access of its participants to city data to train AI, the creation of infrastructure for joint decisions, the identification of issues for AI application. And the last I want to tell that also in 8 days, the law code on experimental legal regimes in field of digital innovation in the Russian Federation will come in force. So I tried to be sure.
Thank you very much, and we'll pick up on a couple of those points and drill a little deeper shortly. But let me first move on to hear from Matthias Spielkamp next, again, on the most crucial priorities for regulation and the scope that it should have.
From our position, there's a pretty clear answer to that, because what we need right now is a lot more transparency. And I already hear the reactions to that, that people say, yeah, but transparency is not really a panacea, because it is maybe going to show us a little more what is going on, but it's not going to address the really critical questions. But I tend to disagree, and we as an organization do so, because transparency is a means, it's not an end in itself, that's clear. But without transparency, we will not be able to understand what is actually going on and where we need to find, for example, domain-specific regulations on certain sometimes technologies, we rather call them socio-technological systems because they're all embedded into a context. And I think the documentary film provided a couple of good examples of that. And I cannot refrain from also commenting on that because I share Daniel's impression that, for example, Michael Kosinski was featured rather uncritically there. And it's pretty clear that, he's sort of peddling nonsense when he's saying that you can use AI to detect all these traits and you can find out whether some person is trustworthy or not. And it was a little sad to see that this was not put into context. And there are other people who have a very broad sense of mission and who say, yeah, we created a God. And as Mark Stegmark said, and it really makes it hard to trust these systems if they are learning by themselves and they become intelligent and make their own decisions. Machines don't make decisions. People make decisions. This is why people are responsible and why we need to hold people accountable. We can't hold technology accountable. There is no way to do that. And we need to really understand this. And if we want to achieve this, we need to have these transparency requirements. First of all, I mean, they're not going to be sufficient, that's clear. But first of all, we need these transparency requirements that tell us when systems to automatically make decisions, to defer decisions that usually are made by humans that are delegated to machines, which is a fact, it can happen, where they are used and what models they use, what technology they use to achieve this aim, and what purposes they are used for. If we know more about this, then we can have an informed discussion. But for example, in Europe, and we know this pretty well because we have done a report that covers 16 European countries and looked at automated decision-making systems that are used in these countries. These systems are used without any kind of transparency at all. Sometimes the organizations, it can be private institutions, it can be government institutions, are not even saying that they're using this kind of technology. For example, predictive policing, including facial recognition. So they're not even telling their citizens that they're using these systems. Sometimes they tell the people that they are using the systems, but don't provide any information about how they are working and what they are supposed to do, as with the system of risk indication that was already mentioned. And sometimes if they do mention what they are supposed to do, they don't provide any more information that would be required to understand better how the system actually works. That's the explainability or explicability question that was already raised in a different panel. And this is where we need to work on right now. We need a clear-cut regulation on providing this level of transparency. And then we can debate, when we have this transparency, for example, what else we need to, let's say, challenge discriminatory practices or practices that promote injustice instead of justice.
Thank you very much. And since you raised that point, Matthias Spielkamp, let me just bring in one question that I have here from an audience member, Professor Ingrid Schneider from the University of Hamburg in the field of ethics and information technology. And she asks, how can discrimination be prevented? Do we need to extend the current list of protected classes in the human rights framework? For example, social inequalities are not necessarily included yet.
Are you asking me?
Yes.
Okay, well, that's a very tough question because I think the underlying assumption here is one I share, and that is that these systems can be used to classify people into categories that are not protected by the law and that can then still be used to discriminate. Now, why is it such a hard question? Why I would also enjoy to hear other panel members' opinions on this is, why is this such a hard question? Because it's rather unthinkable to protect all these categories of people that we have no idea of what they will be, because this is what the pattern recognition and the statistical methods are being used for in order to do this kind of classification. And then, of course, we have to decide whether it's unfair to discriminate, for example, on the grounds that, I don't know, people live in the north of Berlin and drive a car. Should that be illegal? it depends on, I'd say, the outcome and what it is used for. But it's one of the harder questions that the field has to deal with.
Thank you very much. And let me go now to Peggy Walker, and as CAHI Vice Chair, ask you to expand a little bit on why CAHI chose the particular scope and proposal that, in fact, it did, and that we just heard about a moment ago from Gregor Stroyin. That approach, according to the feasibility study, recommends a combination of binding and non-binding instruments, as we heard. So would you just take us through, from your point of view, the advantages that that would have, but perhaps also where there might be drawbacks?
Certainly. Thank you so much for the question, and it's a pleasure to be here. Thank you so much for organizing this. Would you like me to immediately focus on a question about the combination binding, non-binding, or am I allowed to say also something about the scope, which was the question you raised before?
Absolutely. Please do that as well, and then move right on to the next question as well.
Okay, I'll try to be brief, but you know that my main profession is being a university professor, so in law, and they tend to speak always too long. So please interrupt me if needed. So when you regulate or when you look into the need for regulation, it is, of course, absolutely crucial to understand what you want to regulate. So this is one of the first things that the CAHI also looked at and studied. And as you rightly pointed out, we also came to the conclusion that for the moment, there is no single universally accepted technical or legal definition of artificial intelligence. It's a set of technologies, but there have been very good descriptions developed by technical organizations, by academic institutions, by political organizations. And there's a very nice compilation of that made by the European Commission's AI Watch Observatory. And I would like to quote from the report of Ms. Bergamini, the report that accompanied the Parliamentary Assembly's recommendation and resolution on the need for democratic governance of AI adopted in September last year. And that's where they describe, deliberately not using the word define, but describe the term artificial intelligence as the computer systems that perceive and derive data from their environment, use statistical algorithms to process that data in order to produce results intended to achieve predetermined goals. So autonomy, adaptiveness, so self-learning are crucial characteristics of what we mean if we use the term artificial intelligence. In the beginning of the conference, reference was made to intelligence, or artificial intelligence is non-biological intelligence. Intelligence is being able to perceive, to reach your goals. And so nowadays, indeed, most AI is what they call narrow AI. There are predetermined goals, and then AI looks for a way to meet them. Now, having said that, we will spend more time in the coming phase to try to come up with legal definitions, but at the same time, learning from the experience of the European Commission's high-level expert group on AI, we have to make sure that we don't spend all our time on simply defining what we intend to regulate. There are examples out there, and I love to use this illustration. People who have heard me before will know that, and that's the Oviedo Convention of the Council of Europe, where provisions have been adopted in the field of biomedicine without the convention giving a precise definition of what biomedicine means. If we talk about a set of technologies, a technological field, a discipline, like nuclear energy, or in the case of the Oviedo Convention, biomedicine, then we understand what is meant by it. And then once we come to the provisions, we can more precisely determine what we mean with certain terms and what it is that we want to either enable, facilitate, or prohibit. So we didn't need a definition of biomedicine in order to prohibit human cloning, to prohibit the development of babies in order to carry out research experiments. So this should also be something that is clear. Now, about the combination of binding and not binding instruments, I think the advantage is obvious in the sense that in order to have a binding instrument, you need to reach consensus. And consensus might be more easily reached over, I'd say, the more general principles that should guide the development and the use of AI in different sectors. We've heard several already today: explainability, transparency, respect for human rights, respect for privacy, etc. But when it comes to the nitty-gritty, then it might be, soft law might be much more flexible to reach that. And also when it comes to setting up a procedural mechanisms like certification schemes or auditing schemes, then there might be a general provision in the binding instrument, but then the details should be sorted out in other instruments that are developed in close interaction with all stakeholders involved, ranging from public authorities to industry to also civil society, etc. So this is the advantage of an approach that consists of a combination of binding and non-binding instruments. It reconciles effectiveness on the one hand, due to the binding provisions, with the flexibility that is inherent in soft law instruments.
I think staying with exactly that point, and on the basis of what we also heard from Mr. Shipitsin and Mr. Iida, there is concern out there about moving too quickly and too prescriptively and too granularly, that could chill beneficial innovation. What would be your response to that particular argument, particularly given the fact that we are dealing with a moving target where the development of this technology is so rapid that it's sometimes very, very difficult to conceive of where it might be going?
Well, my response, I know there are these concerns indeed. I mean, we've heard before in previous panels calls for binding instruments, that we should act now, that there is some sense of urgency because this technology is developing so fast. At the same time, we've had in the discussions at CAHI and in the working groups also voices out there who call for prudence, who call for being careful with over-regulating artificial intelligence. How will we deal with that? Well, I think the answer is simple in the sense that, well, simple and not simple, but simple in the sense that in the upcoming activities and working group meetings, we will simply discuss how far we can go, what is acceptable by all parties who will have to support from a political viewpoint this instrument. So I would say let us go as far as we can, as is desirable, and where we cannot reach political consensus, we will have to leave that for the time being, at least, to soft law instruments. Now, let me also underline that it is not CAHI's mission or task to negotiate about a convention. The remit of CAHI is to prepare that, to prepare a text that could serve as a starting point for what may happen after the end of this year. So political negotiations are still about to start.
Thank you. Thank you very much. So let us now go on with a deeper dive, essentially, on how you build an effective and feasible framework using the kind of approach that the Council of Europe is working on within the context of CAHI. And I'll go back to Matthias Spielkamp, if I may, and ask you what you see as the most promising building blocks, for example, when it comes to regulating automated decision making, where there is considerable risk of adverse consequences, for example, due to unconscious bias. Would you want to see binding obligations for developers and deployers of the technology, or would you want to rely on a rights-based approach that focuses on those affected, or something else altogether?
I come back to the idea of or requirement of providing more transparency and use the opportunity to dig a little deeper into that, because what we are asking for is clear, binding duties to provide information about the systems that are being used. So it is a clear request for a binding instrument. Now, this still is sort of in the middle, on a different level though, in this discussion about what exactly is it that we need to regulate. Because I do agree that it is a moving target and we need to come up with very good ideas to not quash innovation, also allow smaller organizations, smaller companies also, private companies, to come up with good ideas that are then not put into a position where they need a huge legal department to fulfill all the compliance requirements. Because if we chose that path for governance and regulation, we would run the risk of basically cementing the position that we already have at the moment, which is highly problematic, where we have power concentrated in the hands of a very few global companies that can spend, first of all the money on research, that have the best technology at hand, that have the biggest troves of data, and that also have usually the best talent because they can pay the best money. So we need to also increase the opportunity to come up with new ideas and to challenge these organizations. Now, transparency, of course, is also a compliance thing. You know, if you are required to provide this transparency, there needs to be oversight. There needs to be mechanisms that actually control whether this transparency is provided. But why we are saying it's sort of in the middle is because we are not asking to, in some cases we do, you know, when it comes to facial recognition, for example, in public spaces, but in very few such cases, we ask that a certain implementation of the technology should be prohibited. But we need to understand what a certain system is going to be used for, to then make sense of, is that first of all an appropriate purpose? Secondly, is it well done? And thirdly, you know, are there actual mistakes that can always happen implementing something? You know, mistakes always happen, but is there a redress mechanism that then enables people who are affected by these systems to actually counter these decisions or actions that are being made? So this is why we say we are sort of seeing ourselves actually asking for binding instruments here, but on a certain aspect of the field.
Thank you very much. Let me stay with some of those issues and go to Daniel Luffa. And Daniel, as we just heard from Peggy Walker, in order not to over-prescribe, the approach that is being recommended by CAHI would enunciate basic common principles and then leave those to be contextualized, and would only get more granular in regard to particular applications and risks. So in your area of specialization, which is facial recognition and biometrics, do you see a current need for granularity all the way up potentially to red lines? Matthias just talked about active prohibitions, and if so, what would that look like?
Yeah, thanks. I certainly do see the need for red lines. And just maybe as a way into that, I would just like to talk about a topic that came up just a bit earlier, which was innovation, and the idea that we don't want to hamper innovation, we don't want to kill innovation. I mean, we don't want to hamper socially beneficial innovation, but there's a lot of innovation that really could do with being hampered. I think it was Natalie Smuha that raised it earlier. regulation on biomedicine has hampered innovation in human cloning, and that's a good thing. We can also hamper innovation in the development of biological weapons. And I think things like facial recognition and, the type of research being done by people like Mikhail Kosinski needs to be hampered and to be stamped out because it has no social benefit. Not only does it have no social benefit, it poses an absolute threat to human rights. And it's not a question, again, I would really like to highlight this, it's not a question of it posing a risk, because that gets us into a language then and a discussion of risk mitigation. And we see this a lot in our work, that we see companies selling facial recognition software and claiming that it's GDPR compliant, or that it doesn't actually identify people, it just surveils their appearance. And you get into all of these questions about making it work better and comply with certain regulations, whereas the very core of the problem is that the system exists at all, that it fulfilling its basic purpose is the problem. And for systems like that, the only way to deal with that is to have red lines. I think we've seen over and over again that, ethics initiatives, self-regulatory frameworks, while they have their place, for these egregious, violations of rights, they simply will not be enough. May
I just ask you, because we had an audience question which unfortunately just disappeared from my screen, but it basically was asking, if you do have areas where red lines are needed, at what level does that need to occur? Because, and I would add to that question, if it's only done, let's say, in the region of Europe, won't the technology stay in the world, simply go somewhere else and be developed further, because there will be plenty of other actors who will still want to use it?
Right, this is a really juicy question. I'm a philosopher by training, so I love picking apart this. There's a few myths going on here. One is about this kind of AI arms race. That if we in Europe, for example, don't develop this tech, someone else is going to develop it and we'll eventually be forced to buy it. We don't have to. AI is not a unified thing that we either buy in fully or we totally opt out. We can have absolutely no use of remote biometric identification in public spaces, and that is totally fine, and we can still, be a world leader in natural language processing. So it's not an all in, all out. And that idea that, someone else is going to do it, so I might as well do it, is just an absolutely bankrupt argument. I think what can happen is if we, in Europe, for example, say we're not going to do that, we're going to say no to these things because they're fundamentally in conflict with our values. What that will do is it will actually show an example of how a society can move forward and show an example, and maybe other societies are going to adopt that. And I think also I'd like to push back against the idea that it's only in Europe that we're concerned about ethics. We're in contact, Access Now is a global civil society organization, and we're in contact with colleagues from all over the world where activists, grassroots organizations are pushing back against things like facial recognition. It's not just happening here. We can look to Hong Kong, we can look to Brazil, India. There's big campaigns, grassroots campaigns from people who, accept that this, and this again, to come back to the question that our Japanese colleague raised a while ago, what society do we want to live in? And I think there's a real acknowledgement that some of these technologies are fundamentally incompatible with any kind of a society that we would want to live in, and that, banning it. And again, like, we can get into this maybe a bit later, but it's complex about what a ban means. It can come from high-level international institutions. It can mean companies opting out. It can mean, city mayors deciding that they're not going to allow this in their city. So we're looking into all the different levels upon which we could make this happen. But again, statements like that, I think, are just riddled with harmful myths about, that kind of undermine the idea of how in control of our future we are.
Thank you very much. Let me now get a beyond Europe look at some of these issues and go first of all to Mr. Shipitsin. You talked about Russia's view that formal legal frameworks are needed, binding legal frameworks. I wonder how you see this issue of red lines and potential prohibitions on certain uses. Is that something that Russia could sign up to?
So in this case, I want to say a thing that is very common for all of us. So first of all, we need to think about the balance, and the balance. We all speak about the balance, but everyone feels the balance not the same. Maybe if we'll say that AI will be used in all the spheres of life, so it's hard to define universal red or green lines. As we believe that is the best is the risk-based approach. So for specific AI applications, it's more adequate. So, and we use this approach while we are working on our legislation, and that's our position for the international legislation.
So let me just follow up then by asking if you would say a bit more about where you see the most problematic risks. For example, there's been a lot of discussion in the first panel and in this one about facial recognition technologies and the dangers that they pose. Then we've also heard quite a bit about automated decision making and the risks of unconscious bias. Are those areas where you would say absolutely we are concerned, and that might be an area where we would need more granular red lines?
Maybe the main thing is human health and something like this, but if we say about the legislature too, there must be some common rules for all the spheres. So that's why we're on this. I believe that all our jurisdictions are on the stage when we shall not make any difference between the facial recognition and some other spheres. So just to make the to work on the regulation, the common regulation for all these spheres.
Okay, thank you very much. And let me also now go to Mr. Yoichi Ida once again and ask how you see this area. Would you say there are some uses and applications that are so problematic that we do need prohibitions?
Okay, thank you very much for the question. Maybe please take this as my personal opinion, because I'm not fully representing the country. But no, actually, to be honest, we are learning now, and facial recognition can be one of the something beyond red lines or automatic driving. And some services related directly to the human lives or health or even privacy. But basic idea, you know, for example, let me take facial recognition. There is one field trial which is run by the government and also the private sector together in one city in Japan. They are using facial recognition for providing the services to the people, the visitors and the tourists to the town. And they do not, you know, they make the information on how they collect the images and where they put the cameras and how they handle the data very open to the people. And of course, they obtain the admission from the visitors. And so this is very transparent, and people do not worry about the data taken by the camera and also how those data are used. So I think, you know, in most cases, the technology is used by people, and abuse are done by people. So under the concept of Society 5.0, we are trying to maximize the benefit of the technology. And one of the most focuses in the plan is how to raise the literacy and how to educate the people to make the best use of technology. And of course, there is some elements related to ethics and some, the common sense of the people in not only developers or business service providers, but also the citizens and the consumers. So if there is a common understanding and common knowledge and information among the people, there can be a lot of space where the voluntary governance or non-binding regulation can work. Still, I'm not denying the possibility to introduce binding rules, but we believe, that can be, that should be minimum, and that should be sectoral rather than horizontal, because, in most cases, the risks emerges in a very specific context.
Thank you. Thank you very much. I'm tempted to go to Daniel Luffa for a response to that, whether transparency and a sectoral approach could possibly obviate the need for a blanket kind of a red line. But would you answer that in 2 sentences? Because we're really short on time.
No, that's the answer. Okay. No, I mean, for certain applications, transparency helps. But I mean, again, we've identified certain red lines, and for those ones, it just doesn't. I fully support everything Matthias has said about transparency. It's a necessary first step to know how systems are going to function. But I think there are other systems, other applications where it doesn't matter if we know how it works, because it works in such, contradistinction to rights that it simply can't be allowed.
Okay, thank you very much. I would like now to ask for super short answers because we don't have a lot of time. Maybe our hosts will let us go a little bit over, but there are 2 things I really want to address. One, I'm going to put to Peggy, and then I'm going to ask everybody to give me a very quick view on how you see the comparative advantages and role of the COE. But first of all, to you, Peggy, because we do see there's clearly a lot of variance between countries, between regions on the need for and feasibility and shape of regulation. So given the fact that clearly an international agreement in some form would be very, very helpful, what processes, institutions, and instruments are out there that can promote exchange and try to build some form of trust, or at least also transparent communication on these issues?
Thank you, Melina. I assume that your question relates to the role that the Council of Europe can play in this regard, because, generally speaking, there are the fora of the United Nations, there's OECD, there's the G7, G20, that all could play a role, but allow me to focus on the role of the Council of Europe in this process.
Absolutely, Council of Europe, but how it also interacts with these other stakeholders to get that kind of broad multilateral exchange and trust building. Yes, absolutely. So let me first highlight why the role of the Council of Europe is a crucial role. I see 2, perhaps 3 reasons. The first reason is its unique focus on human rights, the rule of law and democracy. And that makes its intervention different from, but, and this is very important to underline, complementary to what is being done in other fora like OECD, the European Union, UNESCO, G7, etc. A second reason is the territorial scope of the Council of Europe, which encompasses many more countries than only the EU member states. And so the Council of Europe has shown on multiple occasions in the past that it's able to associate countries even from all over the world in its legal standard setting process. And I think an excellent illustration in this regard is the Budapest Convention on Cybercrime,
which has now, that was the status in December 2020, been ratified by 65 states, and another 4 states have signed the convention but not yet ratified it. And these states include also Australia, Canada, Israel, Japan, the United States, etc. And perhaps a third reason that makes the Council of Europe special, that is the way in which it operates. And now I come to your second question, and that is that the way the Council of Europe functions and the way CAI also functions is that it gives ample opportunity for multi-stakeholder dialogue. From the early stage of the CAI, we have involved observer states, we have involved stakeholders from industry, from academia. We've worked with other international organizations like the European Commission, like UNESCO, and it will continue to do so. Does that make the work of the Council of Europe redundant? No, I think that's what I've just explained elaborately. So I'll stick to this.
Thank you very much. And now I'm just going to go straight down the panel and ask for a very brief thought from each of you on how you see that Council of Europe role going forward. And I do have an audience question here that also goes to this point. Would a COE convention or a suggested framework for a convention have the potential to become globally relevant, for example, even in the US, Canada, and Latin America? So I'll, again, just go straight across the panel, starting with Matthias Spielkamp. Just a quick word, how you see it.
Pretty big question for a short answer, but the good thing is that I can basically underscore everything that Peggy said before when it comes to the role of the Council of Europe and also the conventions, the Budapest Convention as an example. So yes, I do think that there is this opportunity to become really influential if the Council would propose such a binding instrument. I can really say that I would be very supportive of that, and we as an organization, because for now, the documents that the Council has produced on artificial intelligence and potential regulation have been outstanding. So I would be really optimistic also on a substantive point of view that this could be very, very relevant. And then, of course, there is this much bigger question of, will some countries join? And this is not just in the hands of the Council of Europe. If you look at the United States and the policy change that is happening right now, if you were at the beginning of the Trump administration, of course, it would be blatantly clear that they would have no interest whatsoever for these multilateral agreements. But things change, the world changes. So I'm continuing to be very hopeful.
Thank you very much, Daniel.
Yeah, I would, back up everything that Peggy and Matthias just said. I think for us, again, the documents, the work that's been produced on AI by the Council so far has really been excellent and is fundamental to our work. And I think, I'll just give a quick anecdote, which was I participated in another consultation on an international framework on AI, which I won't mention. And the decision was to go with an ethics approach instead of human rights, because there was a worry that countries which are a bit uneasy about human rights would not be inclined to sign on. And I think what we can expect, and from the Council of Europe is not that kind of cravenness to do that and to really push human rights. And not to water it down. So there's both the potential for real international sign-on, but we're sure that it won't be watered down to meaningless ethical principles.
Thank you very much. And now that view from beyond, let me start with Yoichi Iida and ask you, how do you see the Council of Europe's role? And we're kind of segueing into our next panel as well with this question, because it asks about Europe's role as an international standard setter. Certainly there's a perception here in Europe that the GDPR in some ways has become a gold standard. And I wonder how you see that in Japan, Mr. Iida, and if you think there's a role here for the Council of Europe in regard to AI that could resemble that.
Okay, thank you very much. Yes, actually, I share the same recognition with other speakers that the expertise and accumulation of achievements in the field of human rights and the rule of law and democracy is the strength of Council of Europe anyway. And I have personally, I have been joining the discussions on AI in the forums such as G7, G20, and OECD, and the GPAI and others, and they mostly focus on economic side and the positive aspects of AI and the technologies. But so the discussion here is a little bit different focus, and I see a lot of things to be learned by digital experts or economists, and interaction will be very valuable, I believe. And also, you know, there can be some influence between different frameworks or different discussions. So I also echo the opinion by Peggy and other speakers. There can be some chances for different frameworks to learn each other.
Thank you. And Mr. Shipitson, your view on this role of Council of Europe and a potential comparative advantage there as an international actor?
So I'll try to be very short, but I need to think about a couple of things. So first of all, the Council of Europe was initially established to form a common European legal space. So, and this committee of CAHI is tasked creating a legal framework that would form a legal basis for our development in Europe, but we believe, and perhaps in globally. So, Council of Europe can serve a platform to organize a committee for the parties of relevant AI regulation. This committee could develop recommendations on the application of the treaty and relevant methodology, discuss possible problems, collect and distribute best practices on AI regulation. So the implementation of the comprehensive legal instruments and AI should stay within the competence of national authorities. So I'll try to be sure.
Thank you very much. And I think Peggy Walker actually made that quite clear in her earlier remarks about the fact that the Council of Europe and CAHI have that kind of essentially role of recommending, suggesting, and setting out potential frameworks, but clearly much devolves then to the national authorities. And that brings me to one very short, very last question to you, Peggy. And I'm going to mix an audience question with a question of my own. Obviously, there are diverging points of view between different national governments on these extremely complex and sensitive issues, but there's also very divergent capacity in terms of legislative capacity, regulatory capacity, science-based evidence for policymakers. What, if anything, can the Council of Europe do to support its members in that area? And then the question from the audience member is whether you think that there actually could be and should be national referenda organized to decide about the use of AI systems.
Let me start with the last, about whether there should be national referenda. I believe this is a decision that every country should make for itself, because the traditions differ from one country to another in that respect. Now, what can the Council of Europe do in order to support members or even non-members in the implementation, I would say, of principles and rules over which we can find consensus? There are various mechanisms. In the past, for instance, in the context of the Framework Convention on the Protection of National Minorities, there are different reporting obligations. I have myself assisted in the past in Council of Europe initiatives in Eastern Europe in the framework of setting up independent media. So there are, on the one hand, support mechanisms, and on the other hand, I would say monitoring mechanisms that exist in the framework of the Council of Europe in order to ensure that what is agreed upon in the texts, in the recommendations, and sometimes binding instruments like conventions adopted by the Council of Europe, that they not remain simply black letter law, but that is also implemented on the field. So this is, and also diplomatic channels, so there are various mechanisms out there.
Thank you. Thank you very much to all of you for this wide-ranging and very, very interesting exchange. We will now move straight on with our next item in our program, but I'll say thank you to all of our panel for being with us, and of course, thank you again to our audience for your participation and your questions.